This is Michael Popok, Legal AF. There is a rebellion breaking out in the federal courts about the Voting Rights Act. We have another example about it today. This might be my easiest hot take today. A 3-member panel of the 8th Circuit Court of Appeals got it completely wrong, and they don't care about whether individuals can bring their own suits to challenge aspects and violations of the Voting Rights Act related to voting rights. You might be thinking, well, if individuals can't do it, who can do it? Well, if under this new ruling, the only people throwing over 50 years plus of precedent, dating back even this past June with the United States Supreme Court, the only people that the 8th Circuit judges believe can bring a case to enforce voting rights for people of color and other people who have been historically disenfranchised is the federal government, just the Department of Justice. Nobody else, which sort of works when the Department of Justice is in the hands of a party who is trying to protect voting rights, right? When there's an alignment, but when there's a misalignment between who's in the Oval Office and their Department of Justice and the rights of people who are disenfranchised, generally black, brown, people of, other people of color, other gender issues, that kind of thing, then you've got to let civil rights groups like the ACLU, the American Civil Liberties Union, or the Southern Poverty Organization, or other individuals who band together to challenge whether a voting map, like let's say in Arkansas, like this one, does or does not violate the civil rights of other Americans. As the dissenting judge in today's decision for the 8th Circuit, because it was a 2-1 decision, one Busher, one Trumper, and a Bush chief judge in dissent, as Chief Judge Smith said, we're talking about core fundamental voting rights. Nothing is more essential to a democracy than voting. And you can't just leave it to whoever happens to be voted president and controls the Department of Justice. You got to be able to let individuals bring the case. Now, the majority, because they want to quash the ability to enforce voting rights, that's their number one thing. Disenfranchisement, suppression of the vote. In order to do that, they finally got their way by ruling today that despite 50 years of precedent, including United States Supreme Court precedent, allowing groups like the ACLU, like individuals, exactly the group at issue here in the case, to sue under the Voting Rights Act, despite that precedent, and the fact that they've allowed hundreds of cases like this to be filed? No. According to the 8th Circuit, because Congress didn't build in the language back in 1965 under the Johnson administration, which was addressing these issues, didn't bake in language to give a private right of action to individuals. It must mean that Congress back in 1965 only wanted the Department of Justice to handle this. Which again, as I said, doesn't matter like today with the Biden administration, because Merrick Garland is spending at his department is spending a fair amount of time filing cases under Section 2 of the Voting Rights Act. Yay! But then if the other guy gets in, he basically puts the Department of Justice and its Civil Rights Division and its Criminal Voting Rights Bureau out of business. And so for 4 years, the rights of fellow Americans to voting, to enfranchisement, is just ignored or trampled. That's what happens. Now, why did I say it's an open rebellion? Because this is now the second example of a court, one now in Alabama over the summer, and one now the 8th Circuit Court about an Arkansas case that just thumbed its nose. That's my thumbing of the nose at the Supreme Court itself, saying we don't care that just this past June, you allowed a similar case led by a civil rights group, led by individuals who you declared implicitly had standing, which is the fundamental ticket into the courthouse. You got to have standing to bring your case. You have to show an injury, has to be personal to you or just separate from what's the general public at large, and that gives you standing. That's the first test to try a case in federal or state courts. Does this party have standing? But the federal courts historically, and the United States Supreme Court dating back 50 years, including just this past June, have declared and ruled that those parties had standing, because if they didn't have standing, the Supreme Court would have tossed the case on standing grounds. Nope, not to the Eighth Circuit, not to Judge Stage, who's a Trumper who wrote the opinion for the Eighth Circuit. He said, I don't see it in the text. Now they're textualists. Where is it in the text that says a private right of action exists under the Section 2 of the Voting Rights Act? And if it's not there, Congress didn't mean it for it. And I don't care what the U.S. Supreme Court, which is ultimately their boss, has to say about it. Well, I got worse news for the Eighth Circuit, because now they've stepped in it. Because the person that's going to stand between this breakaway republic of the Eighth Circuit, a new civil war, if you will, over the Voting Rights Act. Sound familiar? Which party is always doing that? They're going to have to get by Brett Kavanaugh. Now, some of you might be thinking, oh, I hate that guy. Why is that the guy? All right. So Brett Kavanaugh, every Supreme Court justice is assigned a circuit to ride over that circuit and be the judge for immediate appeals from that circuit to the Supreme Court. So every circuit has a assignment, right? The DC Court of Appeals, for instance, sitting in Washington, if you're going to appeal them, you got to go through Chief Justice Roberts. Eighth Circuit, you got to go through Kavanaugh. Why is that bad for the Eighth Circuit in this matter? Because just in June, Associate Justice Kavanaugh joined with Roberts to join the three Democratic appointed judges, Sotomayor, Ketanji Brown Jackson, and Kagan, to form a 5-person block to find that Alabama violated the Voting Rights Act Section 2, breathing new life into the Voting Rights Act, because we thought Section 2 was sort of on life support, the ability to regulate and to stop the disenfranchisement of people, and to use that as a test. You know, we got two things going on here. Kavanaugh, having just joined in June, do you think when the appeal comes up from the Eighth Circuit, which is coming by the ACLU, on the standard of whether, the question of whether individual civil rights groups and people have the right to enforce and protect their own voting rights and have standing to do so in federal court, what do you think Kavanaugh is going to do? He just ruled and against much of, I'm sure, his political leanings, and leaned the other way and joined the liberal majority and voted for the Voting Rights Act Section 2. So now when he gets the appeal, he's going to say, well, I don't know now. Maybe Judge Stage was right. Maybe we've been wrong for 50 years. I don't think so. But this just shows you that there's just this open flouting of Supreme Court precedent. It's almost like they don't care. The Fifth Circuit doesn't seem to care much. Texas federal judges don't seem to care much. Arkansas federal judges, because this came up from an Arkansas Trumper judge who ruled that, I don't see anything in here that says the ACLU can be the party to enforce voting rights. We got to wait for the federal government. Because in their fevered dream, these right-wing MAGA, what they want is Trump to get back in office, the Department of Justice to be emasculated, no cases being brought under the Voting Rights Act, and then the average person or the civil rights groups can't do it either. And so people are disenfranchised during an election or re-election campaign. Do you see it? That's what they're trying to do. And the Supreme Court is going to have to put a stop to this, consistent with their rulings about Arkansas and about Alabama, consistent with their rulings about Alabama and all the other places, and Mississippi. So I think even though there's a couple of judges who have questioned, Alito and Gorsuch have questioned whether Section 2 of the Voting Rights Act, you can bring it personally if you have a private right of action, but I don't think there's enough votes to rip away the Voting Rights Act Section 2. But we will see, and we'll continue to follow it. One place, the MeidasTouch Network, and this Legal AF Breakout podcast. We do it on Wednesdays and Saturdays, only on Legal AF at 8 p.m. Eastern time, and then you can pick it up on audio platforms wherever you get it. We sit at that intersection of law, politics, and justice so that you don't have to, but we don't blow smoke or sunshine. And we're going to report on the Voting Rights Act and the attempts by the MAGA right wing to, in a 2 or 3 step process, go back to suppressing and disenfranchising the vote for people of color and others who have historically been undermined and under the thumb of the majority in this country. Every time it happens, we're going to call it out right here and let you make the decision. So until my next hot take, until my next Legal AF, this is Michael Popok reporting.
Hey Meidas Mighty, love this report? Continue the conversation by following us on Instagram @MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.